Welcome to the New Books Network.
Hello, and welcome to Madison's Notes. We are the official podcast of the James Madison Program in American Ideals and Institutions, and I'm your host, Laura Laurent. This week, we welcome Professor Joel Alicea. He's professor of law and director of the Center of the Constitution and the Catholic Intellectual Tradition at the Columbus School of Law at Catholic University of America. Specifically today, we'll be speaking about the Second Amendment. In 2022, the Supreme Court heard New York State Rifle and Pistol Association versus Bruen. That ruling had significant impacts on the methodology used for evaluating Second Amendment cases. We discuss the implications of this ruling and how it relates to originalist versus contemporary interpretations of the Constitution. Well, Professor Alicea, welcome to Madison's Notes. It's exciting to have you here in person on Princeton's campus. You graduated in 2010, so it must be nice visiting again.
It's always nostalgic to be back on Princeton's campus, and I'm delighted to be here.
Well, so today you're coming to campus to give a lecture on specifically Bruen in the founding era conception of rights. So first of all, to set the stage, we're going to be talking about Bruen, which was a 2022 Supreme Court case. And can you give us a little background about, first of all, what that case was arguing, and specifically what was the major change that it brought about for the understanding of the Second Amendment?
Sure. So Bruen was a challenge to a New York law that restricted the carrying of firearms outside the home. You had to have a special justification to carry firearms outside the home. And that was challenged on Second Amendment grounds. So in terms of the narrow question before the court had two kind of narrow questions. One was, is there a right to carry firearms outside of the home under the Second Amendment, which the court had not yet had to confront before Bruen? That issue was pretty straightforward based on the text of the Second Amendment, the right to keep and bear arms. And so New York didn't even really contest that question, and the court squarely held there is a right to carry firearms outside the home for self-defense. The more difficult question was, were the restrictions on the right to carry outside the home that New York imposed constitutional under the Second Amendment? And to answer that question, the court was going to have to establish, or at least clarify, what methodology, what legal test it was going to use to evaluate the constitutionality of firearms regulations under the Second Amendment. And the court adopted a methodology that it attributed to a prior Supreme Court case called District of Columbia versus Heller. So in Bruen, it adopted a methodology that was based on the text and the history of the Second Amendment without any further inquiry into whether the government's justification for its law was a compelling one, whether the court thought that the way in which the government was going about achieving its goal was a good way of doing that. Those are the kinds of questions that are usually asked in what are called the tiers of scrutiny, which we can talk about. But the court brushed aside that way of approaching constitutional law represented by the tiers of scrutiny and instead adopted a text and history approach. And that's the major thing coming out of Bruen is the methodology it adopted.
Mm-hmm. And so can you explain how this two-step test is contrasted so starkly with the tiers of scrutiny, and what was insufficient about the tiers of scrutiny for answering this constitutional question?
Sure. So I think that both the tiers of scrutiny and the Bruen test could be thought of as focusing on the means and the ends that the government is putting forward. So under the tiers of scrutiny, which is a mode of constitutional analysis, the court analyzes whether the government's interest, what it says it's trying to achieve with the law, is compelling in the case of what's called strict scrutiny, important in the case of intermediate scrutiny, or just rational in the case of rational basis review. Those are the three tiers of scrutiny. And so the court first asks, what's the end that you have in mind? Is it compelling, important, rational? And then it asks, has the government tried to achieve that end in a way that is suited to the level of scrutiny involved? So if it's strict scrutiny, which is the hardest level of scrutiny, the court asks whether the means chosen to achieve the compelling interest are narrowly tailored, meaning it has to be one of the, if not the only way, one of the very few ways in which the government could have achieved the goal that it was trying to achieve, right? Intermediate scrutiny, it's a little looser. The means just have to be substantially related to some important end, right? And rational basis is the easiest, so it just has to be a rational means for a rational end. And in all of those tiers of scrutiny, the court is asking itself whether it thinks the end the government is trying to achieve is compelling, whether it thinks that the means chosen to achieve that end are sufficiently tailored and proportionate to the end. And so it is, as the court said in Bruen, a judge-empowering interest balancing test. And it's very common to see the tiers of scrutiny in constitutional law, especially in the free speech doctrine, equal protection doctrine. It used to be very common in free exercise doctrine. It still is in pockets of free exercise doctrine. So we're very used to, as lawyers, the tiers of scrutiny. But there's been a lot of critique of the tiers of scrutiny in recent years. I've been one of the scholars who has critiqued them. And the court in Bruen rejected them. Now, your question was, well, how does that contrast with what they did do? Well, what they did do instead was establish this test where the first question is, does the rights claimant's conduct fall within just the plain text of the Second Amendment? So in Bruen, for example, those rights claimants wanted to carry arms outside the home for self-defense. Well, those rights claimants were themselves part of the people, as the text of the Second Amendment says. They were trying to carry arms, so the object they're carrying is an arm under the Second Amendment, and the conduct they wanted to engage in, carrying outside the home, is bearing arms. So on the text, looks like they're within the protection of the Second Amendment. So under Bruen, that triggers a presumption that the rights claimant's conduct is protected. And now the burden shifts to the government at step 2 of Bruen to show by historical analysis that the kind of regulation it seeks to defend has an end, an objective, and a means that are well rooted in our historical tradition of firearms regulation. That is to say that there is a historical principle that encompasses what the government is trying to do here, both in terms of the means and the ends. So again, like the tiers of scrutiny, we're focused on means and ends at step 2 of Bruen in any event, but it's a historical inquiry rather than an interest balancing inquiry that the court undertakes based on its own views as it is under the tiers of scrutiny. So the reason this is such a big deal is because it shifts the analysis away from the judge's views about the underlying regulation to a historical analysis of the underlying regulation. And in doing so, the court disagreed with the unanimous views of the courts of appeals, all of whom had settled on a tiers of scrutiny approach to analyzing Second Amendment regulations.
Mm-hmm. I want to go into natural rights versus positive rights and maybe how the founders conceptualized those two things when framing the Constitution and how that could help us understand the way that constitutional issues are brought up in court today. And so can you clarify for us the difference between like a natural right and a positive right first, and then we can go into how the framers maybe understood them differently than how we view them today?
So I think just taking a step back, in general, natural rights as they've been understood in the American tradition refer to rights that exist apart from government. So it assumes a kind of social contractarian state of nature way of thinking about political authority and government. And natural rights are those rights that you would have in a state of nature before government existed. So they are mostly just capacities, things like speaking, thinking, writing. These are self-defense. These are things that you would be able to do quite apart from government existing or not. But under a social contractarian model, once you enter into society and into a political society with government, those rights can be regulated for the common good. Now, some aspects of those rights are what are called inalienable, which is to say there is no way in which the government can have control over those rights because they're so core to what it is to be a human being. So, for example, the freedom of thought. But there are other rights, natural rights, that are retained natural rights, and these are subject to government regulation. Positive rights are those rights, what we might call fundamental positive law rights, are those rights that would not exist as a matter of natural right, considered in the abstract, or natural law considered in the abstract, but are concretizations or determinations of natural law or natural rights through representative institutions. So, for example, the right to petition the court for a writ of habeas corpus, which is a key procedural guarantee of our liberty of person, right, going all the way back into the common law. Nothing in the natural law or natural rights specifies that there ought to be something like a writ of habeas corpus. But the writ of habeas corpus emerged out of our law over many centuries as a guarantee of things that are natural rights, such as the freedom to be free from bodily restraint arbitrarily, like not subject to law. That's what habeas corpus is supposed to guarantee, that if you are being bodily restrained, it's according to law, right? So those are the three categories that a scholar who I've engaged with in my own work, Judd Campbell, has laid out in his work. We have inalienable rights, retained natural rights, fundamental positive law rights. And those first two categories exist apart from government. The last category only would exist in government because it is about a concretization or specification of natural law, natural rights through the positive law.
So I'm curious to apply maybe an example first, because when you were describing natural rights, you said reading, speaking, etc. And when I first heard reading, I was like, but somebody has to teach you how to read. Would then like a positive right be the right to an education? Is that a reasonable application of this theory, just to check on my own understanding of it?
I think that rather than conceiving of natural rights as things that you could do by yourself, you might instead think of natural rights as things you could do apart from a governmental actor or governmental body, because there might be some things that, and I actually would be curious to know what Professor Campbell would think about this. There might be some things that are natural rights and yet do entail a social relationship apart from government. It's really the emphasis is more on, are there things that you would need a government to exist for in order for these things to become rights? And that is something that is true for fundamental positive law rights because, for example, the petition of habeas corpus makes no sense, right, apart from a government.
Okay, no, that makes sense. One of the critiques of Bruen is that it treats the Second Amendment's text as rigid, while revisionists say that the founders saw rights as more flexible for the common good. I'm just curious how you respond to that.
So I think that critique involves misunderstandings of both Bruen's methodology, but also in some ways misunderstandings by the critics of their own view of rights at the founding, in that on the first point, the methodology and Bruen's methodology, actually leaves significant room for legislative determinations and adjustments of rights and duties with respect to the conduct of carrying firearms, just to take the Second Amendment example, right? Because unlike the tiers of scrutiny, under Bruen, once the court has determined as a matter of text and history that certain conduct is not disabled from being regulated, it's up to the legislature to determine when and whether to regulate it, right? And that's not subject to reevaluation by the judges later as to whether they think the legislature was right in saying that there's a compelling government interest here, or that this is the best way of achieving that interest. The tiers of scrutiny is essentially a reevaluation of the legislature's judgments in a very legislative way. The judge is asking, was this a compelling interest? Well, obviously the legislature thought it was, because that's why they enacted the law. And so there really isn't under the tiers of scrutiny the same kind of freedom for the legislature to make those quintessentially political judgments without being subject to their homework being checked by the court on those political judgments. What Bruen does instead is say, well, no, what we're doing as a court is simply making legal judgments. And our legal judgment is based on the text of the Second Amendment and how it was historically understood. And apart from that, it is up to the legislatures to make determinations about this conduct, whatever the conduct may be. In the case of the Second Amendment, it's carrying arms or bearing or possessing arms. And so I think that's a misunderstanding of Bruen's methodology to say that it's very rigid and it doesn't allow for a lot of legislative running room. I think it does within the boundaries of text and historical tradition.
When we define tradition, is it about specific laws, broader principles, commentary on it? Like when we look at the historical tradition, what are we including in that analysis?
So this is a contested question in the scholarship right now because some scholars have interpreted Bruen as requiring the government to point to specific historical statutes and only statutes that are similar to the statute that the government is currently trying to defend, right? So the government's current law would have to look like some statutes that were enacted like in the late 1790s or early 1800s, right?
When I hear that initially, I'm like, the principles are important. Yeah, I'm curious what the pro-con of that specific position is.
So I'll get to that in a second, but I just want to emphasize what you said there at the end. The principles are important. I think that is actually what Bruen is also saying, is that what we're looking to is the law that existed near the time of ratification of the Second Amendment to see what were the legal principles that bounded the Second Amendment right. And whatever the government's trying to do today needs to fit within those legal principles. But it doesn't have to be an identical law or even a very, very similar law to a law that exists in the 1790s, because obviously there could be real changes. For example, there is a historical tradition based on laws at the founding of restricting the possession of firearms in certain locations, like within a courthouse, right? And there, you might be able to derive various principles, criteria, based on the kinds of places where they excluded firearms and say, okay, well, those criteria might then allow you to include new places as places where you could exclude arms from, like airplanes, right? If airplanes meet those criteria. But it doesn't have to be an identical law to the ones in the 1790s, because obviously they didn't have airplanes. And they didn't have a lot of the same concerns that we have now about some sensitive places. So as long as the historical principle is being respected, the same criteria are being applied as were applied at the founding, it allows for adaptation to modern circumstances. Bruen, I think, properly understood, should be conceived of that way. But to your question, well, why do some scholars interpret Bruen as requiring something much more narrow and much more stringent? I think it's because, a variety of things. One is that Bruen repeatedly talks about the historical tradition of firearms regulation. And so that has led a lot of scholars to think, well, I guess all that matters here is actual regulations. And Bruen focuses a lot on statutes, on historical statutes. And so that, again, has led a lot of scholars to think you have to find a statute. But Bruen also cites a lot of other kinds of historical sources. It cites treatises. It cites newspaper articles. It cites floor debates in Congress. It cites a lot of sources that are not historical statutes as part of its historical inquiry. And that makes sense because Bruen, by its own self-presentation, is a search for the original meaning of the Second Amendment. And the original meaning of the Second Amendment is not limited to just what kind of historical statutes were existent at the time. You rely on all sorts of historical sources to figure out what the original meaning of a provision is. That's just standard originalist theory. And so I think it's a misreading of Bruen, and really one that twists Bruen into kind of an indefensible methodology to say that all it that it only can be satisfied if you can point to a specific statute.
Mm-hmm. Mm-hmm. No, and that makes sense because that also answers the question of what is included in the historical analysis. The historical test could seem quite vague to some, and that it poses the risk of judges being able to cherry pick which parts of history they want to emphasize. As you see it, is this a significant risk that basically is just as risky as the original way to understand these issues, or is there not actually as much of a loophole as some critics might say?
I think that criticism really proves too much, because the exact same criticism could be turned around on any form of precedential reasoning. So it is just bread and butter of the court system in the United States to look to prior cases, to prior decisions, to determine what the state of the law is now. When you look at those prior decisions, you have to analyze what did this precedent stand for. And that involves an analysis of the facts of that prior case, what the opinion says. But sometimes the opinion says things that are not actually the law. They're just kind of musings of the court, or they go beyond what was necessary to decide the case or important to decide the case. There are all sorts of different ways of conceiving of the scope of prior doctrine, prior precedents. But my point is, in determining what the state of the law is today, a lawyer looks at prior cases, has to analyze them and figure out what is the through line here? What is the principle that emerges from these cases? I see that as no different than looking at a bunch of historical sources and doing the same thing, figuring out what is the through line? What are the principles that emerge from all these historical sources? So if that is just inherently manipulable, subject to arbitrariness, and indefensible as a methodology, then the same is true of the very basis for a precedent-based system like ours, which is precedential and analogical reasoning.
So I want to go back a little bit to the tiers of scrutiny and how they impact the roles of the legislative versus the judicial branch, in that as I was coming to understand the rules of scrutiny a little bit more, it seemed to allocate legislative powers to judicial roles that might not have been intended in the original framing of the Constitution. Is that a correct impression? Is it clear that the text and historical analysis of Bruen somehow alleviates that issue?
So I think that is accurate, that the tiers of scrutiny assigned to judges a role that they were not supposed to have at the founding. Again, I'm relying on the work of Professor Campbell and a bunch of others, actually, Philip Hamburger, G. Edward White, and a lot of other scholars who have shown that this form of reasoning that the tiers of scrutiny forces upon judges, where they are just making kind of largely unconstrained normative judgments, largely unconstrained empirical judgments about deep questions of public policy, there was no conception at the founding that federal judges would be doing that sort of thing under Article 3 of the Constitution. Which is why you don't see any sort of analysis like the tiers of scrutiny emerge until close to the end of the 19th century, and you don't have anything formalized as we currently know it as the tiers of scrutiny until the mid-20th century. So it's actually fairly recent in our law that we have something like the tiers of scrutiny. At the founding, that was not the way courts operated. What courts did at the founding, they applied a lot of different techniques, but they definitely prioritized text and they prioritized historical analysis. Now, of course, our historical analysis is trying to look at, well, what was the understanding of the right at the moment of ratification? If they were living in the 1790s, they sometimes did actually ask themselves that same question, what was intended when this was enacted only a few years ago? But a lot of times when it comes to individual rights, what they were looking to were the pre-existing legal practices, looking at things like what was the state of the law when we enacted the right to freedom of speech or the press, because that will help us figure out what this provision actually meant. And that's exactly what Bruen does. Bruen, at step 2, at the historical analysis, looks to what were the practices and the laws in place when this provision was ratified to recover what the content, the legal content of that right was. And so it seems to me that Bruen's analysis is very much consonant with the kind of analysis that was done at the founding, and that we know from debates, for example, in the first Congress, the founders understood these types of rights to require that kind of analysis.
Mm-hmm. Yeah, and it seems to me as though in reorienting where legislative and judicial powers lie, it can reorient citizens into understanding if they don't like the way something is being ruled on, their best power is, again, in the democratic process of electing legislators, as opposed to putting pressure on judicial means, if that makes sense.
Yeah, I agree with that. I think that a lot of the complaints about controversial decisions the Supreme Court has made, those complaints and those efforts are better directed towards the political process to try to just change the underlying laws. There are restrictions on what can be done through the political process under our Bill of Rights. But those restrictions are there for good reason, because there are certain rights that we have decided to not subject to the political process because they are just fundamental rights. That was true at the founding, and it's true now. At the founding, there were components of these rights that people understood to be not subject to legislative regulation.
Yeah, and what would the founders have said is the risk of mixing the legislative and judicial powers in the way that the rules of scrutiny start to do?
Well, at least with respect to individual rights, I think that the founders would have been deeply troubled by a judiciary regulating these rights for the common good as the judges understood the common good. For them to be determining the limits of these rights and the contours of these rights, for the judges to be doing that through judicial decree, rather than those types of activities, those specifications, determinations of the limits of rights happening through legislative representative institutions, would have been viewed as a real attack on the foundation of democratic government, because the whole premise of social contract theory with respect to rights is that even when we enter into a political society and form a government, we retain our control over our own rights, because it's the representative institutions that shape the contours of those rights, not unelected judges.
Could Bruen's analysis be applied to other rights like free speech, freedom of religion. You said a little bit to this, but I'm curious what more you would have to say.
I certainly think that it could be applied to those other provisions. Whether it should be, I think, is a more complicated question. It depends on a lot of things, at least in my mind. One is, are other rights in the Bill of Rights of the same kind as the Second Amendment, in that they were declaring rights whose content has to be derived outside of the text through historical analysis of the state of the law at the time. So, for example, Step 2 of Bruen requires exactly that kind of historical analysis. You look at what were the practices at the time to figure out what is the content of the right. Well, some rights are like that and some are not, and so you have to figure that out about any given right to see if that's the right kind of analysis to do. But even after that, there's also an important stare decisis analysis that you would have to do. So would the original meaning, would shifting towards something like Bruen, which is an attempt to recover the original meaning, would that just completely upend current free speech doctrine or current equal protection doctrine? If the answer to that is yes, then you have to decide, well, how do we make the transition, and can we make the transition from current doctrine to something more like Bruen without completely destabilizing constitutional law? Because I am not in favor of completely destabilizing constitutional law, and I think that the stability of the law and stare decisis considerations are important. And so I would think it would be important to map out a transition path from one kind of test, the tiers of scrutiny, to something like Bruen in these other areas of law before you undertake that kind of task. In Bruen, the court didn't have to do that because there was no built-up precedent over the Second Amendment. Until 2008, the Supreme Court had not recognized an individual right to keep and bear arms for self-defense as it did in Heller. And after that, there had only been City of Chicago versus McDonald, another case called Quitano, very, very brief case. So really, Bruen was writing almost entirely on a blank slate, except for what Heller had said about the methodology. And so it wasn't destabilizing the Second Amendment case law at the Supreme Court level, at least, by doing what it did. So those kinds of stability considerations would be much more prominent in the free speech domain or the equal protection domain.
I'm curious, so how should courts handle modern issues that the founders couldn't see? You said we need to be adaptable to some of the newer problems, but how would you see courts interacting with the problems or with the concerns that are coming up for us in today's ecosystem? And what I'm trying to get at is, we discussed a little bit how it's not a freezing of law to interpret it, to take this originalist's perspective. And I would love to hear some more examples of how it plays out when courts are addressing modern issues that the founders couldn't.
Yes, it does. And so I think that a good example of that is the court's latest Second Amendment case, United States versus Rahimi. That was a case where you have a federal law that bans the possession of firearms by individuals who've had a domestic restraining order entered against them by a state court with a finding that they were dangerous. Right? And it says under those conditions, it's a violation of federal law for you to possess a firearm in violation of that state restraining order. Right? That's a reflection of a modern Congress having a lower risk tolerance, having a different understanding of how willing are we to allow somebody to carry a firearm when they could be a risk to somebody else's safety, especially in the domestic context. At the founding, there were legal traditions that were very similar to that, not identical though. There were surety laws, which were ways of posting a bond essentially to show that you could continue to carry a firearm despite somebody being worried about you potentially being a safety risk. And there were things called affray laws, which is if you did in fact misuse a firearm, you could be imprisoned and therefore disarmed while imprisoned. And so this statute at issue in Rahimi sits somewhere between those two things. It is both disarming temporarily, like the affray laws, but it's doing so before you've actually misused the firearm. So it's not like an affray law in that sense. It's more like a surety law in that sense. And it seems to me that Rahimi correctly holds that that's fine under the Bruen test because both the surety and affray laws reflect a common end, which is to prevent those who are dangerous with firearms from possessing or misusing firearms and harming others. and a common means, which was temporary disarmament, which is authorized by the Affray laws. And so it does seem to me like Rahimi is an example of exactly what you're saying. A modern legislature having the flexibility to make a different judgment about at what point are we going to temporarily disarm in response to modern concerns about domestic violence, and yet being able to draw upon principles from two different branches of law that formed a common tradition, legal tradition of trying to prevent those who are dangerous from misusing firearms.
I'd love to ask you, since this is your wheelhouse, the Second Amendment is often a contentious subject given America's history with gun violence, in schools particularly. And I'm curious, when you look at the founders' original intent or the reason behind the right to bear arms, what was the significance of putting that in the Constitution to begin with?
The Second Amendment reflects many different strands of political thought at the founding. Just to pick one, kind of the most obvious one, it reflects a skepticism of governmental authority. It reflects a view that a government, even a representative government that seems to be on the side of its citizens today, might at some point become tyrannical. And to the extent that it did become tyrannical, it would be very important for the citizenry to be able to resist that government with arms. And I think that there's actually a lot of history that supports that's a wise decision to ensure that the citizenry can resist if a government becomes tyrannical. I think a lot of moderns today, especially in the West, tend to just have this complacency about government and seem to be very content to say, well, of course, the citizenry is all disarmed. The only people who have arms are the state through the police and the military, and they're very comfortable with that. Especially my friends in Europe, in Western Europe, I hear this all the time whenever I talk about the Second Amendment with them. And I just view that as very historically blinkered, because governments become tyrannical and misuse their power against their citizens all the time in history, including ones that seem like very good governments. And so the idea that there needs to be some sort of insurance policy where, to the extent that the government becomes destructive of the ends of government, that people have the ability to resist through arms if necessary, seems to me to be an important political principle. Yeah.
What would you say is one of the biggest misunderstandings of specifically Bruen, so that as we consider Second Amendment issues going forward, it doesn't get constrained to the critiques?
I think it would be really helpful for the court in a future case to just clarify that they're willing to look at any historical source at step 2 of Bruen, the historical analysis, because that would immediately dispel like one of the major criticisms by scholars, at least, of Bruen, that it's pegging historical analysis just to historical statutes, which again I just don't think makes sense and isn't, I think, what Bruen says. That would be helpful. It would also be helpful for the court in a future case to clarify what parts of the analysis go under what step. So for just this is something that divides some of the lower courts. Some of the lower courts, for example, are confused about in determining what kinds of arms are protected under the Second Amendment. Does the historical analysis of restrictions on types of arms occur under the textual analysis at step 1 or under the historical analysis at step 2? That matters because the burden is different. The burden at step 1 is on the rights claimant. The burden at step 2 is on the government. And so if the burden is on the government to show that there are restrictions on the type of arm that the person wants to use, that's obviously better for the rights claimant than if the rights claimant has to show that there were no restrictions on them at step 1, right? And so those types of questions, which is we're getting a little in the weeds of the legal analysis here, are dividing some of the lower courts. It'd be great if the court would clarify some of those points.
And just for some context, even on your own scholarship, what drew you into looking at these particular issues, and what were maybe the cases that caught your eye when you were a younger student that drew your interest to really focus in? And because learning legal theory is so much reading and learn, of course it is, but I'm just astounded by whenever I speak with legal theorists, which I've spoken to a lot within the last month and a half, or a few, I should say. I'm just astounded by the capacity to remember so many names and cases and details. There has to be some sort of underlying interest or question that bugs you, that keeps you able to keep coming back.
Yeah, I think that for me, the motivation to explore these theoretical questions has always come back to questions of political legitimacy. So I mentioned earlier, a theme of this discussion so far has been the legitimacy of judicial power exercised in certain ways and the illegitimacy of judicial power exercised in other ways. Originalism has always cared a lot about legitimacy. Is it legitimate for federal judges to invent a right to abortion, for example? Is it legitimate for federal judges to water down rights that were much firmer at the founding, like the Second Amendment? And my answer to those types of questions is no, right? That originalism is an attempt to recover what the people decided when they enacted a constitutional provision. And that is what they're bound by, not by what judges decide to create, but what the people themselves decided through their enactment. And that requires, in turn, all sorts of political theoretical premises to be in place to support what I just said, right? You'd have to build up a case that we should care what the people said in 1789 or 1788. Or 1791 in the case of the ratification of the Second Amendment. And I've done that in other work where I've tried to provide a natural law defense of originalism. And all of that really began with my time here at Princeton, actually, because I took courses with Professor Robert George. And so my interest in constitutional theory, constitutional law, very much began here under his tutelage, but also Professor Keith Whittington's and others. But then I was also exposed to natural law theory, again, by Professor George and others here at Princeton. And so a lot of my academic career thus far has been an exploration of how those two things interact with each other. The natural law theory side of my interests and the originalism and legal theory side of my interests. How do those two things, what's the relationship between those two?
Well, thank you so much for your time. I just appreciate your clarifications.
Oh, it was my pleasure. This was a lot of fun. Thank you.
Thank you for tuning in on this episode of Madison's Notes with Professor Joel Alicea. If you're interested in hearing more about this topic, he gave a lecture at Princeton University in the spring of 2025, and that YouTube video can be found on the James Madison Program's YouTube page. If you're interested in more content like this, make sure to follow, like, subscribe on all of your favorite listening platforms, and you can find our social media pages under the James Madison Program. Madison's Notes is researched, hosted, produced, edited, and engineered by me, Laura Laurent. And if you have any comments or ideas for future guests or episodes, feel free to reach out to me through the James Madison Program on social media. Thank you for tuning in, and I'll see you next week.